Appeals Division 1 is in session.
Please be seated. Good morning. We are here for oral argument in 1 CA MH18 0067 in re Frederick B. These proceedings are being audio and video recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side has 20 minutes. Appellant counsel, you're responsible for watching the clock to reserve a portion of that time for rebuttal if you desire. We've read the briefs. We've discussed this matter in conference this morning. You may proceed.
May it please the court. Good morning, Your Honors. My name is Mike Penrod. I'm appearing on behalf of the appellant, Fred Brimke. Mr. Brimke is currently housed at the Arizona Community Protection and Treatment Center at the Arizona State Hospital. In our opening brief, we identified 3 separate issues. I would specifically like to discuss, if we can, just one issue today. I think it's the most important. And that issue deals with the October 20th petition for discharge request and the timing on that hearing, how long it took to get to the court. As Your Honors are aware, the sexually violent predator statutes have been deemed constitutional based on case law because it has been found that appropriate procedures and evidentiary standards act as procedural safeguards. One of those procedural safeguards that somebody who's been deemed an SVP patient has is the right to petition annually pursuant to 363714 for a discharge hearing. Specifically under subsection B, if the department isn't recommending a change in status, he can still petition once every year. Once that petition is filed, In re Leon G states that the petition then requires a hearing. And then the SVP patient may be present and may participate, and the state has the burden of going forward. Now, in the case before us today, I think it's important, I know Your Honors have read the briefs and are familiar with the procedural history, but I think we need to go through that a little bit more in detail just to lay out the facts a little bit. It's uncontroverted that on October 20th, 2016, Mr. Brimke, through his counsel, filed a petition for discharge. He requested a hearing in the Superior Court. It took until approximately, I believe it was February 6th, 2017, for that petition to be addressed. During this time period, appellant's counsel at the trial level filed 2 separate requests to the Superior Court asking that it be dismissed because he was claiming it was untimely. Those were never addressed, never brought up at the Superior Court level at all.
But I have to ask, why not file a special action during that time?
I do not know why the trial counsel did not. I think that would have probably been a procedure that could have been used, but it wasn't in this case. The February 6th order set it for a petition for discharge hearing on March 21st. The time between October 20th and February 6th is 109 days. In that time period, all that happened, petition was filed, the state responded, it sat dormant for 109 days. March 21st, the hearing that was supposed to be for the petition for discharge, immediately before that, I believe it was about a week in time period, appellant's counsel at the trial level filed a motion asking for sanctions, claiming there was some civil rules of procedure that were not filed in the discovery. That's in my brief as well. At that point, on March 21st, instead of holding the petition for discharge hearing, all that was discussed was basically setting it for a contested or an evidentiary hearing on this motion for preclude. The discharge hearing was not litigated as was originally scheduled to happen. So that gets kicked down the road. It's set for April 18th. The court then resets that hearing till May 1st. At May 1st, again, the discharge hearing is not occurring. Instead, it's just arguing this preclusion issue. May 1st hearing, it happens. There's nothing else happens until June 16th when the Superior Court issues its order. Not anything to do with the petition for discharge. Rather, it's simply denying the motion to preclude.
I mean, I appreciate your laying out the timeline, and I think it's safe to say that it's disturbing that there's a problem here. But what would you have us do at this point?
The ultimate remedy, Your Honor, is I believe that in a case like this, my argument is a due process violation. That's where I'm going with all of this. I think you all know that. My argument would be that Mr. Brimke should be released. And there's...
Well, what prejudice has he suffered? You say, I didn't get my hearing, but he got his hearing. It was late, but he got his hearing. Is there something in the record that would indicate to us that the hearing was somehow prejudiced because of the delay?
It occurred 467 days after he requested it.
That's the delay. I asked, is there anything in the record that would indicate he was somehow prejudiced because of the delay?
On the merits.
I believe he received a hearing. I believe it was litigated correctly. I didn't find any issues there as far as what occurred at the hearing. So my argument for prejudice would be in line with the case law that I cite, which would be Fuller. Now Fuller, as the state points out in its response, is pre-adjudication, pre-finding of the person being sexually violent. But again, it deals with the timing issue and the time constraints not being found. And in Fuller, it talks about specifically prejudice in these SVP cases, and one of which can be an improper delay standing alone can support a finding of prejudice.
Let me ask, if the hearing had been timely held, is there any realistic prospect in your mind that your client would have been successful on this record, where he refused to participate in the evaluation?
On this record, I don't believe there would be, unless the Superior Court had granted the motion to preclude the evidence that was untimely disclosed.
So it would be anomalous, then, to say a remedy for a procedural default on the part of the state or the court is to give somebody relief that was not warranted on the record, wouldn't it?
Well, I agree with that, but let's pose a hypothetical. Suppose the hearing hadn't occurred for 10 years. Wouldn't that be prejudicial?
Well, except we require people to take actions or remedies that are available to them. And your response to Judge Swan's question about, well, why didn't you file a special action, was, I don't know. I mean, he clearly had a remedy available to him. If the trial court's abusing his discretion, the remedy is to ask the Court of Appeals to tell the trial court to get off the dime and hold the hearing.
And I agree that should have been done. I unfortunately was not the trial attorney.
But if he refuses to participate and no blame directed your way, but doesn't take advantage of the remedies that do exist, how does he then ratchet those failures into a result so good that the record doesn't even justify it on the merits?
And that's a fair question, Judge, and that's one I've struggled with in this appeal. But I think keeping in mind that everybody's due procedural due process and substantive due process, and I think we're dealing with an egregious violation of that. The state only made one request for this hearing to go forward. That was in July of 2017. And the Superior Court, frankly, I don't know if they just bypassed this case or forgot about it, but it just sat around for 250 some odd days with every hearing never being set. So I think that...
But the result then is that we expose the community to potential harm?
I think due process applies to every person, Your Honors, myself, as well as the worst of the worst.
No doubt that that's a correct statement in the abstract, but due process law also looks at prejudice to help fashion remedies for violations. I don't mean to plant seeds, but if there is a due process violation, there are civil remedies available for that don't necessarily go to endangering the community.
I would agree that's probably potentially an option to Mr. Brimke. But at this point, I know Mr. Brimke, he wants out of custody. He feels that his rights were violated. That's why we're here.
He could participate next time around in an evaluation and perhaps secure that relief.
And I do agree, and I know that's been advised to him. So I think we've fleshed out the majority of my argument. I would just ask the court to consider the Fuller case. It's not directly on point, but it is the closest I could find. I think the closest the state could find as far as dealing with a time limit being violated in an SVP context. And in that case, they agree that this is a draconian remedy. It's a hard remedy for people to probably accept, to let somebody out of custody that might have these sort of issues as Mr. Brimke. But I think due process requires that some remedy be put in place. And I think the only remedy to justify this sort of error is
Well, we've
for
talked about
dismissal.
two alternative remedies. One is diligence in pursuing enforcement of the right to a prompt hearing, and the other is a civil remedy. But how do we tell somebody who might be victimized by your client that we let it happen because of a court error?
I hate to point blame to anybody, and I don't think the blame would be pointed at the appellate court if he was to be released. I think that can be attributed to the state for not diligently pursuing this case, and perhaps the Superior Court for, I don't know what the reason why it took so long. But it happened, and it's a peculiar case, like Your Honor said, but it doesn't excuse that a violation occurred. And my argument is I think that it requires Mr. Brimke to be released. If there's nothing further, I'll reserve the remainder of my time for rebuttal.
All right, thank you. Counsel?
Morning, Your Honors. May it please the Court, my name is Michael Shumway. I'm a Deputy Navajo County Attorney, and I represent the state of Arizona, the appellee in this case. I think I'd just like to start addressing a few of the points that the Court's hit on. Mr. Bremke's attorney said the state didn't fail to diligently pursue the case. I think this is a little bit different than the cases, the Fuller case specifically, where the state really didn't commence these proceedings. I think if you look at it in light of this petition, Mr. Bremke essentially was the plaintiff in this case. He filed the petition. And so, yes, I believe that the case law says the state has a duty of going forward with these, but that's in the light of those initial SVP proceedings. The state files a petition when it's notified that the Department of Corrections is going to will be terminating a sentence on someone who meets the criteria under the statute, who's been committed of one of those enumerated crimes. The state then files that initial petition. Then there's a burden that was put on the state in those cases.
But that's a troubling position because here he's been convicted of no crime, and you're suggesting that once the state gets him committed, the burden is on him to be released. Otherwise, he stays in custody his entire life. That's a dramatic proposition.
Just when I don't think that's exactly what I'm not intending to suggest that. If that's
the logical consequence of your position?
Well, I believe that the state clearly has the burden to continue to prove beyond a reasonable doubt that Mr. Bremke needs to be confined, that his mental disorder has not changed once that's filed. I think we're talking about if the state has essentially the burden to file a request for a hearing. I think that's really what we're talking about in this case. The state, I don't think, would be in a position to have filed a special action asking the Court of Appeals to order the trial court to conduct a hearing. And that's all I'm talking about is this gap between the state's response. Mr. Bremke filed his petition in October. The state responded on November the 3rd. Defendant replied to that on November 10th, 2016. Then it sat dormant. He asked for a request regarding ruling on December 22nd. The order wasn't docketed until February 6th. That order technically, though, is dated December 29th. I don't know what happened on those 4.5 weeks between when the order was signed and when it was docketed, but it was actually signed December 29th. If you look at the record on appeal, that's the record 256. It was signed in December. So, I mean, it's not within 45 days necessarily, but it's also not 109 days. I mean, I understand the docketing versus the signature issue.
So right now you seem to be focusing on dividing responsibility between the state and the court. And I hear you suggesting that any due process defect here was the court's fault.
I think that the state...
Or are you saying there was no due process defect?
Honestly, I don't think there was, because I don't think that subsection B of 3714 has a 45-day requirement. I think that's laid out in the briefing, That pertains to subsection A, which...
And someone who is SVP can request a hearing and the court could hold it 10 years later.
I think there should be a reasonable time limit, but I don't think that...
Was it reasonable in this time, in this case?
I think for the initial setting, yes, it was. The initial setting was set in March the following year. I don't know what the court's calendar is. I don't know how the court manages that calendar. Subsection A is when the treating physicians have determined that this person has been rehabilitated. The case law upholding the SVP statutes, I think, is very clear, explaining that the purpose of these statutes is not to punish, it's to rehabilitate. It's to give these individuals treatment in the hopes that they can reintegrate into their communities. And so once that has happened, that's what subsection A is for. That's where that time limit becomes imposed.
But Mr. Shumway, a Superior Court judge is supposed to resolve matters within 60 days once they become at issue. In this case, the judge didn't set a hearing within 60 days or hold a hearing within 60 days from the time you filed your response, did it?
No, Judge. I mean, I'll concede the hearing did not happen within 45 days. I'll also concede that it wasn't a continuance or some other sort of postponement as has been discussed in the case law.
Even if there's no 45-day requirement, can 460 days ever be reasonable?
Probably not, Judge, but some of that time limit, those delays for the full 460 days were not really anyone's fault. I mean, I guess my worry is what it was the state exactly supposed to do.
Well, that's not necessarily the question, right? Even if the state is blameless here, it seems likely that there was a deprivation of due process. And I don't really hear you disagreeing with that.
I mean, I think this case definitely shouldn't have taken as long as it did. I don't know where we put blame in, and I think the biggest problem I think the court is honed in on during the other half of the argument is that where's the prejudice exactly, and what's the remedy? If you look at the case law on those, the Fuller case, the Ulgadi case, those were initial. There had never been a determination beyond a reasonable doubt that those individuals were sexually violent persons, and so I believe that it's an apples to oranges comparison in this case because Mr. Bremke has been determined that he's a sexually violent person. He's continually refused to participate in treatment, including, it's not before the court, not in the record, but the latest annual review came out last week. He still didn't participate.
Well, let's not deviate from the record.
Understood.
But if we assume that there was a due process violation, and one of the ways I get there is the statute contemplates an annual filing. This hearing didn't occur until after the next opportunity to file had already occurred. So one would have to infer, I think, that either constitutional due process or even the legislature's own intent was violated here. I don't know that it's that important to assess blame, but I would ask you, if you don't strenuously disagree with anything I've said so far, what your recommended remedy would be.
I think that the key is that I think the special action is where this kind of jumped the rails. I think that's the remedy. I mean, it's provided for. It was available for the defendant, for Mr. Bremke, to ask for a special action and ask for the Court of Appeals after the second time. I mean, the first even request by Mr. Bremke didn't happen within 45 days. That didn't happen within 60 days. So even Mr. Bremke wasn't all that interested, if you will, in pursuing a timely remedy. I mean, he didn't file those until the end of December. It had been pending for over 60 days at that point, or even, and so it's just one of those things where, I mean, I get it. The court should have, in my opinion, the trial court should have set a hearing sooner than that. I mean, I think it has to be kind of a reasonable person standard, and what's reasonable. The first hearing was again set for March of 2016. I don't know why there was a delay between the signing of an order in the end of December until March. I don't know what was on the court's calendar at that point. And so I don't know why there was that delay. But it was there. If Mr. Bremke felt like it wasn't rapid enough, he could have also filed a motion to accelerate the hearing, could have filed another, again, a special action would have been available to him to say, look, this has already been delayed long enough, I shouldn't have to wait all this extra time, and that just didn't happen. And so ultimately, I think he has to bear some of the responsibility to push forward and to exercise his rights.
So your position then would be that if the SVP doesn't diligently pursue rights in the Superior Court and failing that in the Court of Appeals by way of special action, that there really is no remedy?
I think that's, yes. I don't see how, when the record establishes that this is a person who suffers from a mental disorder that puts the community at risk, I cannot just get to a point where the remedy is allowing this person to reintegrate into the community. And so I believe that, yes, the court should have held a hearing more rapidly. I disagree that it's a 45-day requirement. I think that was put in place. I think that it's fair to say that 45 days is a very quick turnaround from initial petition to disposition in a case. And so I believe that that is not, you would have to read that into the statute where it doesn't exist to impose a 45-day deadline on this particular case. You have...
At what point in the statutory and judicial process is the person's right to counsel implicated?
I believe it from the outset. So Mr. Bremke has had an attorney since 1999 when the initial petition to hold him pursuant to the SVP statutes was filed. It's my understanding that as soon as the state files that, that triggers his right to counsel. He has a right to a preliminary hearing and then has a right to a trial. Either side can request a jury trial. In this case, he exercised his right to counsel. At the preliminary, they requested a preliminary hearing, but at that hearing, a stipulation was signed submitting it to the court on the record after an examination was undergone.
And then how about after that has concluded, when he's a committed person?
I believe he is entitled to an attorney throughout that proceeding, Judge Johnson. Okay. And he has had an attorney. I think the record establishes that Mr. Ron Wood was his trial attorney since 1999, has been receiving the quarterly and annual reports, which kind of goes into the disclosure issue that was raised but not discussed yet. And so I believe he's had an attorney the entire time, and so it's not a case of him just not understanding the law and not exercising it due to a lack of counsel.
Okay.
I think it's worth noting, too, as far as the prejudice goes. The prejudice that was found in Fuller was because that person was held for 20 months. He wasn't provided any treatment. He wasn't provided the annual reviews, those kinds of safeguards that are in those statutes. In this case, Mr. Bremke was still provided with the opportunity to participate in treatment, which he's declined repeatedly. He was still provided the opportunity to an annual review. And so that really was the prejudice that was found in those cases when they didn't happen within the statutory required time. The prejudice wasn't just that it was too long. It was specifically that the purposes of these statutes are to rehabilitate these individuals. And because they hadn't ever been adjudicated as a sexually violent person, that treatment wasn't provided to them. Those services weren't given to them. So that's really where the prejudice came in. I don't believe there's a case where it was intrinsically held that the delay was so prejudicial that it warranted dismissal and release. It was specifically tied to the purposes of the statutes being to rehabilitate these individuals and those services not being provided to those people who were just essentially held on a probable cause determination without having gone through that trial or that beyond a reasonable doubt consideration. If you don't have other questions on the 45 days, I would like to touch on the other 2 points that were raised in the briefing. As far as the examination goes, I don't think that there's any case law on this. I would ask the court to hold that when a sexually violent person declines to participate once the examination is offered, that then they've waived that waive that right.
Waive which right?
The right to be examined annually. So Mr. Bremke has said because he hasn't been examined within the definition of the statute. I believe the state, because the reports indicated that he was unwilling to participate, and then it was based on a lot of other factors. It wasn't current information.
I would tend to agree that the SVP can't manufacture error by refusing to participate. But let's take your position to its next conclusion. If the SVP waives the right to be examined, the state still bears the burden of proof beyond a reasonable doubt. Yes?
Correct.
So the waiver itself is not conclusive of the petition.
Sure.
Okay.
I just don't think manufacture error, I don't think he can say I'm not going to participate and that the state should somehow have to, essentially what's been suggested is that the state should have asked the trial court for an order requiring Mr. Bremke to submit to the examination. Then if he failed to do so, ask for a contempt order, which realistically is not going to secure his participation. This is an examination. It's not like a blood draw in a DUI case or a warrant to take an x-ray of a person to see if they're carrying drug-filled balloons in their stomach, where it can be secured without that person's consent. I think the SVP statutes, it's a mental health issue. That examination requires some sort of participation by the person. And so there's really no way for the court to order you to participate. Yes, could we have removed him from the state hospital and pursued a contempt order to where he was incarcerated in the county jail instead? I don't know that that's going to secure his participation. The Holt case.
I don't know that you could get a contempt order because there's no requirement that he participate.
Well, if we asked for an order, I guess that's what was suggested in the appeal.
But what would be the basis for the order? If you asked for an order compelling participation, what would be the basis for the court to grant that?
I think, based on Mr. Bremke's interpretation of 363708, it says the state shall examine the defendant annually. He's now arguing that that the state is compelled to perform this examination. And so then the state should have taken this extra procedural step to ask for an order pursuant to that statute that Mr. Bremke be examined and participate, and then ask for a contempt order if he failed to do so.
What if during the term of commitment, the SVP becomes a quadriplegic but still declines to participate? The SVP could, in that case, potentially win release, right? Because the facts surrounding his danger to the community would be evident without a psychological examination.
I'm not an expert in that, Judge Swan. I don't know. Hypothetically, I guess that could be possible. I would be hesitant to say that you couldn't still prove beyond a reasonable doubt that he poses some danger to the community. But it's not my field of expertise.
But it's possible to imagine finding that he's not a danger to the community in that extreme situation. Right?
Sure, in that extreme situation.
So potentially, if you back off those facts a little bit, a non-participant in an evaluation could still have a fairly debatable petition for release.
That's probably fair.
Okay.
I think the last issue was the discovery sanctions. I think the biggest issue here is the Allstate case, where the disclosure rules aren't supposed to be reduced to, I think it's quoted as an arsenal of technicalities. I believe Mr. Bremke was provided with all of the information. His attorney received the same reports that the state received, and that's the totality of this case, essentially, are those reports. Quarterly reports dating back to the year 2000, annual reports, all of those were provided to counsel. Ultimately, I feel like if the transcript reflects that the trial counsel was just upset that it didn't take a specific format, as opposed to being provided with the information that was needed. Who would testify? What would they testify to? If you look at those reports, they're on letterhead. There's ways to get a hold of those people based on just those reports alone. The disclosure, the state didn't make disclosure until March 15th of 2017 that was called disclosure. The state did, however, file a motion for a telephonic appearance of its witnesses on March 3rd, which was 20 days prior to the initial setting of the hearing. So at that point, even though a technical disclosure statement had not been filed, the state had explained who it planned to call and asked for a telephonic appearance on behalf of Dr. St. Clair. And so I believe that at that point, the defendant was aware, Mr. Bremke was aware of the information that would be presented. He would have the ability to contact that doctor if he so chose, through his counsel, of course, and to ultimately do whatever investigation might have been needed to be able to go forward with that hearing. And so I do believe that the trial court made a sound ruling in denying that request and did not abuse his discretion. If there's nothing further, I would just ask this court to affirm the trial court in all of its findings. Thank you.
All right, thank you, counsel. Mr. Penrod.
Thank you, Judge. I want to turn our attention back to the timing issue. I know that we've talked about it considerably between Mr. Shumway and myself, but I did not bring up our contention that the 45 days in subsection A, our contention is that it applies to any discharge hearing. I think if we look at that statute and read the plain reading in it, there's no exclusive terms in that statute saying when a hearing pursuant to this statute is requested, the hearing must occur within 45 days. Rather, when you read that statute as a whole, it talks generally about discharge hearings.
Well, but it didn't put the 45-day requirement in a general provision. It put it in subsection A and left it out of B.
I agree. But I think, like Judge Johnson said, is that nowhere in that discharge hearing language of that statute does it talk about the right to have counsel. That's in another statute in another subsection within the general provision of the SVP statutes. So I'm not going to say that it's a poorly written statute. I just think it might not be the clearest. But I think, Judge Swan, you brought up a good point, is that even if the 45 days does not apply, if you disagree with our contention that it does, surely there has to be some time period here. Like Judge McMurdy said, 10 years, Mr. Shumway consented, that wouldn't be reasonable. He seems to imply there's some reasonable language in this statute.
I think there's general agreement. Mr. Shumway even agreed that 460 days is probably not reasonable.
Correct.
But that's not the hard question we have.
The remedy. I agree. And it's tough. But like the case law said, I think it was Gold, it said the remedy is draconian, but that is because the trial court and the prosecutor, the state, failed to prosecute the case diligently and to manage the case efficiently to make sure it was set in a timely fashion.
Oh, but you failed. You weren't doing the representation, but the SVP person failed to prosecute by not filing that special action.
Correct, but I think if we look at the record, he did take several steps. Mr. Shumway makes it seem like the petition was filed in a reply and that was it. There were two other pleadings, one at the end of 2016, one in January of 2017 that were never addressed. We talked about that. Then if we look at the transcript of the May 1st hearing, trial counsel Mr. Wood, again at the end of that hearing says, Judge, I'm paraphrasing, Judge, we've been waiting on this hearing for a long time. We need to get this set. We have to litigate this. He made that request now, 4 times plus a reply? And that's
it. Sounds to me like you really teed it up for the Court of Appeals to grant you relief if you had filed that special action.
I agree, Your Honor, and I wish I had been on this case. But I agree with Mr. Shumway. The 467 days is unreasonable in this case. I believe it's so unreasonable that it does justify this remedy of dismissing the petition and releasing Mr. Bremke. I know that that is a hard thing to swallow, given the reports, but due process, I think, trumps those concerns. I think we have to be concerned about due process for Mr. Bremke as well as every other person within this state and this country. And he has those rights just as much as any of us. And I don't think we should get our blinders on and say, well, he might have a little lower due process. And I'm not saying Your Honors are saying this, but he might have less due process because he's so ill. I don't think that's the standard. I think it applies the same to everyone.
I don't think anyone in the courtroom has suggested that.
Right. I'm not accusing Mr. Shumway either. Judges, as far as my other two issues, as far as the Judge Swan, you pointed out that he being Mr. Brimke can't refuse and then build in error. I think, though, we're dealing with statutes that have to be strictly complied with. The language is shall. He shall have an annual examination. And then there is the case law saying that there are remedies that could have happened. I think the state or somebody should have filed a request.
Well, let's explore that. If the statute says he shall have an examination and he doesn't have the examination, how can he now claim rights under the statute when the failure to have an examination is exclusively his own fault?
That's a tough question. I agree. But I think that, again, we need to remember Mr. Brimke's.
I thought you were going to say that the Fifth Amendment might come into play, and he doesn't have to participate, which I think would have been a fair answer, but it also doesn't advantage him.
Right.
It means he doesn't have to participate.
Right. As far as the motion to preclude, I think our arguments contained therein state it correctly. The state, in its own pleadings, have acknowledged that they haven't complied fully with the rules of civil procedure. And again, my main issue, the one I'm asking that we mostly focus on, is the prejudice that was done to Mr. Brimke because of this denial to a speedy hearing. Did not occur within 45 days, did not occur within an annual basis. In fact, there's a point that I haven't brought up yet, and I'm glad I thought of it. On June 21st of 2017, Mr. Brimke could have petitioned yet again for an annual review, but he's still waiting for the October 2016 petition. So how many of those have to pile up before he could get a hearing? How many is required? My argument is that it should have occurred at the minimum before the next annual filing by the Attorney General's office. So that's my arguments, Judge. I appreciate your time. If there's no further questions, I'll submit my last 3 minutes and 40 seconds to the court.
All right. Thank you very much, counsel. Thank you very much for your arguments here today. The matter will be deemed submitted. We'll issue a decision in due course.